Dear viewers and learners, today we are going to see another important subject that is called the consumer protection legislation in the post-independence era. In the previous lecture, we have covered the consumer protection legislation past period to the independence period. Thus, the today's lecture on the post-independence legislation is covered under the course code CPI 1, block number 4 and unit number 14 and other units also. Now, let us straight away come to this. What are the, again, like it's in the previous discussion, there are several legislations passed after the independence closely related to the Consumer Protection Act. However, for the purpose of due to the paucity of time, we will take only those legislation which are very, very important and closely related to the Consumer Protection Act. And in this order, first we will take about there are 6 to 7 legislations very important to the and closely related to the consumer protection. These legislations are called the Drugs and Magic Remedies Objectionable Advertisement Act, passed in the year 1954. Then the next major act is called the Essential Commodities Act 1955, which is also a point of discussion about this amendment made in this act is also covered in the farmers related agitation going on these days. Now, the third one is the Bureau of Indian Standards Act 1986. Then the Competition Act, which is in a country like America and USA, this Competition Commission and the Consumer Commissions are under the one umbrella, whereas in India it is kept under 2 umbrellas separately, Consumer Commission and the Competition Commission. In this way, the Competition Act 2002 is equally important. And the Right to Information Act, as we all know, is very, very important. Any consumer who are not getting the relief, who want to get the vital information, they can use this Right to Information Act for gathering the information from the concerned producer, seller, and all other agencies. Then another important list is the food and the Food Safety and Standards Act, passed in the year 2006. Earlier it was called the old act was known as the Food and Adulteration Act 1954, which has been completely modified and brought under the one umbrella of the Food Safety and Standards Act 2006. And another major important list is the Legal Metrology Act 2009. These are the laws closely related to the protection of the interest of the consumers and the promotion of the interest of the consumer. Consumer Protection Act is the legislation dealing with the consumers and the protection of the interest of consumers. But as a consumer, he is having different, he engages in different business transactions. So therefore, all these laws are very, very important. Now let us see what are the first act is the Drugs and Magic Remedies Objectionable Advertisement Act 1954. Now what is the object of the act is concerned? The object of the act is to control the advertisement of drugs in certain cases, to prohibit the advertisement for certain purposes of remedies alleged to possess magic qualities. In olden days, some people they come with the magic. They were advocating. They will cure certain diseases by magics and all those things and all. But those were only to befool the public who are mostly illiterate and all. And the government noticed that this, particularly in the rural areas and all, some of the people are exploiting the this lack of awareness of people to the advantage of this magic shows, and thereby they were exploiting the consumer. So with the view to control such type of advertisement on drugs and cases, to prohibit the advertisement for certain purposes of remedies alleged to possess magical qualities. Now the drugs related to drugs used for internal as well as external use of the human being as well as the animals also. That's what the coverage of drugs is concerned. Now we will see only the very, very important aspects on what type of advertisement is prohibited under the act, that one should understand. Now the type of, not all the genuine advertisements are not prohibited. Only those advertisement of certain drugs for the treatment of certain diseases and disorders. They say that if you are having certain disease, by the magical treatment that the disease will be cured and all. And in the villages, people, they believed it and they paid the money, then subjected to several harassment also, but they could not get results at all. So first is the act specifically prohibits advertisement of drugs for treatment of certain diseases and disorders. Then advertisement of magic remedies is for treatment of certain diseases and disorders which are directly or indirectly claims to be efficacious for any purposes. Then sometimes the advertisements also, they makes a false claim that this magic treatment is far superior than the conventional medicinal systems and all. Then other aspects covered under this thing. Now, what are these misleading advertisement relating to drugs? That also, that as the law code highlighted, what type of advertisement will be treated as a misleading advertisement relating to the drugs is concerned. Now, number one is directly or indirectly giving false impression regarding the true character of the drug. So sometimes they will say that the character of the drug is not disclosed to the people, the false character is projected before the people are concerned. Suppose somebody is having ailment, all they say, if this particular drug is taken, you will be freed from all your miseries and all. So only direct, they will make the advertisement if says that it will directly or indirectly give relief to the treatment concerned, then that type of advertisement, if it is found false, then that is prohibited under the law. Then making a false claim for the drug about the person making the advertisement makes a false claim about the drug, utility advantages and all. Then otherwise false or misleading in any material particular, or if the advertisement is misleading in any material particulars content the drug is concerned, that will also come under the scrutiny of the false or misleading advertisement. Then any import into or export of drugs from the territories to which this act extends, and any document containing an advertisement of the said nature by any person. Suppose wherever the act is made applicable, then any import of the drugs or export of drugs from that territory or including the document related to the advertisement, those things are prohibited. This is in a nutshell that this act is covers and all. Now we will move into the another important legislation, that is the Essential Commodities Act. As I said earlier, Essential Commodities Act primary object and purpose is to ensure regular supply and distribution of essential commodities to the people concerned. That is act. For this purpose, the act empowers the central government to pass orders regulating or prohibiting the production, supply and distribution of the essential commodity, and also the related trade and commerce. That's how the goods are traded or marketed, distributed, transported. Those related are also covered under this. The purpose of the act is to ensure the compliance of the provisions of the act and the orders passed thereunder. That is the purpose, is to ensure the orders passed under this, because this legislation is social welfare legislation. Primary job is to ensure regular and supply distribution. What are the essential commodities? It may be rice, paddy, even the onion, or even tomatoes, pulses, cereals, all those which are very essential for the survival of the human beings concerned. Even oil, this kerosene also, like this, all those things are covered under this. Sugar also is the essential commodity. So then the job is to the purpose to this law is this distribution is necessary in the larger and public interest, because we have the public distribution system where the essential commodities are sold or distributed at a fair price and reasonable price. At times the price of the fair price shop is much lower than the market price and all, because the objective and purpose of this act is to ensure the availability of all essential goods to the poor and needy persons at a concessional, at a reasonable rate. And for this purpose, the government has the authority to procurement of goods also covered under this. Then marketing of the goods also covered under this. Distribution of the goods, all those covered under this. That is how the purpose and objective of the act is concerned. Now we will move into the another important act is concerned, that is about the Bureau of Indian Standards Act is the another important legislation passed in the year 1986. Now the object of this act is to govern preparation and enforcement of standards for goods related to the then this law also provided for the establishment of Bureau of Indian Standards called the Bureau for the harmonious development of activities of standardization and the quality certification of goods. See, we have the ISA mark and all, we all know the Indian standards and certification and all. Now, why this standardization necessary? Because in order to ensure the quality and standards of the product that is sold, a marking is very, very necessary. Otherwise, everybody will know. There are large number of markets available in the market. However, the government, the people, they go for, why they go for a branded item, marked item, ISA mark? Because that type, the commodity or the product which carries the Indian standard mark, that qualifies, that satisfies all the quality standards prescribed for that particular commodity is concerned. That is the reason why the government insists that please look, not only that public, everybody, they look for, they advise the people, please look for the standard products so that the qualities are ensured. Other goods which not having the ISA standards, they need not follow the quality marks prescriptions required for the commodities concerned. Therefore, the primary job of this Bureau of Standards Act is to establish the Indian Standards Bureau of Indian Standards for the harmonious development of the activities of standardization, marking and quality certification goods concerned. Then what the law prohibits primarily? The law prohibits the use of standard and mark about any article or process or in the title of patent, trademark or design except under a license. So you can use a standard mark only after obtaining due license from the competent authority. Without obtaining a license, you cannot use any mark, whether in the form of a patent or a trademark or design. So that is very important requirement of this licensing is very, very important. Then use of any name or mark or trademark which contains the expression Indian standard or abbreviation IS, and also the goods, they should not carry the Indian standard, because it is given, this Indian standard used only with the approval of the authority concerned, that the central government. Those who uses this Indian standard without the approval of the central government, then that is prohibited under the law is concerned. This is about the Indian Standards Act is concerned. Now let us the Competition Act, I said already. Competition Act is passed in the year 2002. Earlier it was earlier act was known the Monopolies and Restricted Trade Practice Act, passed in the year 1969. The job of the Monopoly and Restricted Trade Practice was primarily to avoid monopoly or restrict the monopoly and restricted trade practice. However, over the period of time, that aspect is gone. Now, the elements of, after liberalization, the elements of competition has been inbuilt in the business activities concerned. Therefore, accordingly, the law recorded substantial changes. Accordingly, in the year 2002, the Parliament passed the law called the Competition Act 2002. Now, what is the objective and purpose of this act is concerned? The objective of the act is to provide for the establishment of a competition commission for the purpose of, or to prevent the practices having adverse effect on the competition, to promote and sustain competition in markets, to protect the interests of the consumers, and to ensure freedom of trade carried on by other participants in the markets in India is concerned. So again, I would like to make it clarify that the primary job is to establish the Competition Commission. Already we have the Competition Commission of India, they have the head office in New Delhi, and the primary job is the job of this commission is to prevent practices having adverse effect on the competition, and also to promote and sustain competition in the markets also, and not only that, it also it's a component of to protect the interests of consumers is very important. Again, analogous to Consumer Protection Act, the Consumer Protection also aims to protect the interest of the consumer. So also the Competition Act is also aimed to protect the interest of the consumer and ensure freedom of trade and carried by the other participants in the market. So if you see that objective of the Consumer Competition Act and the Consumer Acts are by and large the same. Now what are the other, what the Act prohibited for is concerned? Let us throw some light on this. The Act provided 3 to 4 activities primarily. One is the price fixing. Price fixing. If 2 or more suppliers fixes the same price for the supply of the goods, then it will be treated as the restrictive practice. So suppliers should not with the understanding, or otherwise they should not fix the same price for the same commodity, that the supply should have some difference in the price. That is what very, very important. That is called the price fixing. Then bid rigging. If two or more suppliers exchange sensitive information of bid, then it will also be restricted practice. It will be also restricted practice, and it will treat it against the spirit of the competition is concerned. So price rigging also prohibited under the Competition Act 2002. Now the third one, the resale price fixation. Resale price fixation also prohibited. We all know what is the resale and all. When purchased for the purpose of selling it again, a wholesale trader purchasing it for the resale to the retail trader. So this is called the retail. And in situation, price fixation. If a producer sells the goods to the distributors on the condition that he will not sell any other price which is not fixed by the producer. So that no, he says that he should sell the price, only the price determined by the producer. That is not possible, because the seller also needs certain amount of margin for him also. Therefore, if they put any such of restriction, the producer against the trader and all, that will become the resale price fixation. Then exclusive dealing also relates to the restrictive practice. See, in the consumer protection as well the competition prohibit two things. One is the unfair trade practices, which we discussed already, and the restrictive practice. Now we are dealing with the restrictive practice. If a distributor purchases the goods on the condition that the supplier will not supply the goods to any other distributor, so then again it's an exclusive dealing. No, neither the producer nor the distributor put such conditions on the other person concerned. So the producer, the distributor will have the freedom to say sell any goods from the freedom to purchase from any goods from anybody. So also the seller, and also any such restriction is against the spirit of the competition. Therefore, it is prohibited and the act is concerned. Now we will look into another important act that related to the Consumer Protection Act. It is called or known as the Right to Information Act, which was passed by the Parliament in the year 2005. As we all know, it has become one of the revolutionary act which conferred right upon the people to seek information from the public institutions or the public authorities, which were earlier not made available to the public at large. The law put several important responsibility upon the public institution to display all their necessary information in their website, so that public need not approach them for if they need any vital information and all. So the objective of the Right to Information Act is to provide a practical regime of Right to Information Act for citizens to secure access to information under the control of public authorities. The Act clearly defined who are coming under the category of the public authorities: all the public institutions, all the institutions, central government, state government, municipalities or other institutions, and also all the institutions having financial assistance support from the government substantially, and there's public authorities definitions there that you can read our study material, then understand it. Public authority is the public institution rendering service to the public at large. That is what. Then the another object of the Act is also to constitute Central Information Commission and the State Information Commissions. Now the Central Information Commission is seated at Delhi, is functioning, and all each state government is having the State Information Commissions for disseminating required information to the public at large within the respective state is concerned. Then the third object is the Act is also to promote accountability and transparency of or working of the public authorities. Essentially, the job of this act, the primary purpose and object of it is to bring transparency in this in the management of the public authority, and also to bring accountability of the concerned authorities. That's what for a public authority is concerned. So bringing transparency and promoting accountability of the public authorities, these are the essential features of the Right to Information Act 2005 is concerned. Then what is the purpose behind it is the purpose of the act is to empower the consumers to have easy access to the information which are necessary for the from the point of the consumer. Then, as I said, to promote transparency in the working of the every public authority. This is about the important about the Right to Information Act. Now, the important provisions This act, right to information and obligations of the public authority. The law codified and listed what are the obligations of the public authorities, what type of information can be shared with the public's concern, what are the information cannot be shared with the public. Those things are clearly provided in the act is concerned. Then also the law provided for the appointment of public information authorities for each establishment, and also if the organization is very big, then for each divisions or department there must be an exclusive public information officer should be appointed for the purpose of disseminating information as when called by the public. Then the law provided the manner in which the request for seeking the information to be made and the pro forma, how the manner should be made and all that is clearly provided. Including the pro forma, the format, there is no specific format as such. However, the certain general guidelines are provided that we have to make a formal request to the concerned authorities for seeking. We have listed what are we are required, and that should be addressed to the notified public authorities. Even by the consumer is not aware of the public authorities, they can send it to the head office of the concern. Then it is the mandatory on the head office to find out who is the public information officer of the for the particular department. They should send that request to the concerned public information officer is concerned. So that is about it. Then how the manner of display of the request is also provided within 90 days or within the 30 whatever the things are. There are appeal levels are also there. So the timeline and the manner of disposal of the request is provided and the act is concerned. And finally, what are the informations are exempted from the disclosure information. If the information is found to be very confidential, then the public authority need not disclose this information, but those things are provided in the act also. So that is what in a nutshell the right to information is covered. Now we are moving to another important legislation, Food Safety and Standards Act 2006. As I said, the earlier act, the Food Safety and Adulteration of Foods Act 1954. So that act was having certain infirmities, so it lacked certain important requirements as per the post-liberalization era. Accordingly, the Food Safety Act the Food and Adulteration Act 1954 remodified and it was reenacted in the new name of Food Safety and Standards Act 2006. The name itself indicates that this enactment related to the safety and standards of the food related items is concerned. Object is to consolidate the laws related to food and to establish Food Safety Standards Authority of India, and for the purpose of laying down science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale and import, and also to ensure availability of safe and wholesome food for human consumption. So that is what. So it's a very, very comprehensive objective. Already the law, and based on the law, the Government of India established the Food Safety and Standards Authority of India. In every goods label you will find it FSSAI. This is what the short form, which is the authority vested with the power to give the label. They have the power to regulate, monitor on the sale, distribution of the food related items and all. So again the thing is to based on the standards of articles of food and to sale of import, and import also, the import is also covered under this category is concerned. Now what are the important provisions? As I said, the law has already, the government has already established the Food Safety and Standards Authority of India, and the primary purpose of this institution is to exercise the powers conferred upon under the law and to perform the functions assigned to under this act. The authority has invested the enormous powers on the same thing about the distribution and ensure the quality and the standards. Everything is what are the standards prescribed by even the regulatory authorities. This authority has to give the clearance for all the goods meant for the sale and distribution only. Then the law also provided for the constitution of central advisory committees, and the purpose and objective of the constitution of central advisory committee is primarily to ensure close cooperation between the food authority, that is the Food Safety and Standards Authority on the one side, and the enforcement agencies and organization operating in the field of food. There are several regulating authorities are created under various laws, and this job of this committee is to work as a link between the Food Safety and Standards Authority of India and other regulatory authorities, so that synchronization brought between these two institutions concerned. This is what in a nutshell about this Food Safety Standards Act is concerned, and now it is having with a lot of power, including the punity also. They can search, power to search and seizure and seal the articles also. They can ban the article also from the sale also if it is found say hazardous to the health of the people, public are concerned. I don't want to name any of the things are there. Even there was some news item about the honey contained excessive sugar content and all. Then the standard that they had to step into the action, and it has taken the responsibility of testing it whether the honey sold in the market is having excessive content of the sugar than the prescribed level. And also the primary job of the authorities that for every product the quality standards are prescribed by the regulatory authorities. The standard authority job is to ensure, even to verify by way of testing whether that standards, the commodity is sold, whether contain those standards or not. That is the primary responsibility that Food Safety Standards Authority is concerned. Now we are moving into the last important legislation, equally the Legal Metrology Act 2009. Previously it was known as the Weights and Measures Act 1974, and that again after the liberalization, now this law has been modified. Now it is called the Legal Metrology Act 2009. Again this relates to the important weights and measures is concerned. Even olden days, you will show that now people are the trader have the tendency to sell lesser quantity of the quantity of goods than the prescribed quantity by doing the by unscrupulous manner and all. Then they used to fabrication of goods. Then they used to say adulteration of foods. These were the practices followed by this traders and all, with the view to say regulate these aspects and all. The Legal Metrology Act has been passed by the Parliament. The object is to establish and enforce the standards of weights and measures, establishment and enforcement of standards of weights and measures, and also regulation of trade and commerce in weights, measures and other goods which are sold or distributed weight measures or the numbers and all. So this is what the object is. One is the establishment of enforcement standards of weights and measures, and to regulate trade and commerce in the way related to the weights and measures. Weight refers to the quantity, and the measures also, it may be length also, it may be anything, it may be a quantity, quality related, it will be. And length, height, all those things are concerned, weight, measures and goods which are sold in and all. Then important provisions, what the law says, every unit of weight, whether kg or whatever things are, every unit of weights or the measure to be a metric system based on the international standard system of units. So now all the measurement, all the weights and measures adopted by India should be at par with the international system of unit. That's very, very important. Then all weights of measure up to 20 kg capacities will require approval of model before manufacturing or importing. So all the weights need to be or measure up to 20x capacities will require approval of the model before the manufacturing or importing such measures are concerned. These are in a nutshell about this legal metrology. Now let me conclude by saying these are the important legislations that is related to that is passed after the independence concerned, and you might request you to please go through our literature, study material supplied to you, or the website available in the market, and read it thoroughly. You will get more information. With this, I thank you for hearing this lecture. Thank you very much, please.